welcome to How to Sell a Business, a step-by-step guide. This is part 2, and you can read more about financial poise on slide 2 of the deck. Our panelists today are Phil Buffington of Balch and Bingham, Jonathan Friedland, a partner at Much and Shellis, and Brad Pickard of Republic Partners. I'm Tom Goblat, managing partner of Ravinia Capital, and having said that, let's get started. You can see our names on slide 6, and you can read our bios starting on slide 51. Neither Financial Poise nor we intend this to be an infomercial, so you don't have to listen to me read bios. If you want more information about us, just look at our bio slides or check out our LinkedIn. About the slides, I'll try to call your attention to slides that are relevant to whatever we are talking about so you can take notes if you like. But don't worry if you're listening but not watching. This webinar, you'll just fine because the slides are not critical. So let's see here. Financial Poise is supported by our sponsors. MaxX Asset, if you need to conduct an online auction, MaxX Asset is your turnkey solution. Mood, the nation's premier online retail cannabis dispensary. More on that in our deck. The last thing before we begin is slide contains a disclaimer. You're not our clients. We are not your lawyers. We are not, what we do here today is your general education and not for you to act on without appropriate device. Without further ado, we'll pick up where we left off on part 1. So we're going to begin part 2. And so we're going to start with a question for Phil. And can you walk us through, Phil, the different types of purchase price consideration available to a seller?
Absolutely. Good afternoon, Tom and everyone else. They're basic types of consideration. I think they're on slide 13 for people that are looking. I'm not sure if that's right or not on the 13, but anyway, the first
slide
type
11, actually.
Okay, slide 11. The first type of consideration, and probably the consideration of choice, is cash. Whenever you're selling your business, you always would prefer cash, or I won't say always. In a lot of instances, you would prefer cash. There's a give and take on buyers and sellers in that issue. Another type of consideration could actually be a promissory note that you were getting in exchange, where you were doing owner financing. And there are a lot of considerations there. Each one of these is probably deserving of 15 or 20 minutes each, but except for cash. But I won't go in that direction. That's really where you're selling your business on an installment basis. And it's tied a lot to the performance of the business after the fact. If the buyer runs the business in the ground, then you ultimately would take the business back in a foreclosure sale. So that's a downside to it. Another type consideration would be an earn-out performance type agreement, where you could increase the amount of money you were paid over time based upon the performance or future performance of the company. And again, that's putting a lot of the issues in the hands of the buyer and all of the control in the hands of the buyer. But if you're getting initially what you want out of the business with an earn-out going up for future performance, that could be an added on value for it. I will give you an example of that. I've got a transaction right now, and it's a regulated industry, so it's a little bit exception to the rule, but we plugged the purchase price to closing with a minimum amount of cash that was being paid out up to a certain amount based on future earnings over a 6-month period of time that it'll take to close the transaction. So the shareholders in that instance will get a minimum purchase price with an add-on dividend before closing based on earnings up until the closing date. Another could be stock in the buyer. I'm going to speed it up here, Tom. I'm taking a little bit too much time.
No, that's okay. This is an important topic. And after you finish this one, I'm going to kind of have Brad and Jonathan debate out and earn out, but go ahead.
Okay. Next would be stock. And look, going back if you're looking at all of these from a due diligence standpoint, if you're getting cash at closing, you're really not worried about but one thing in due diligence, and that's whether or not the buyer's got the money. And that's really it, and the fact that it can close. The rest of these, a seller note, an earn out, the next one I was going to mention is stock in the buyer's existing company, all would require an extensive amount of due diligence to make sure what you were getting is something that you were going to be able, they would be able to perform on. And then the
Yes.
last would be is where you may, and this could take a lot of different forms, but you may leave part of your equity in the business and stay as a minority shareholder. That could be tied with a redemption agreement over a period of time based on certain performance levels to increase your overall payout. But that's really it. I'll throw in for humor. You could also accept Bitcoin if you wanted to.
Oh, okay. Well, let me, first I'm going to ask Brad to kind of, when he's representing a seller, to talk to him, to guide on what you advise your client on, when it's a good time to take an earn out and what are kind of some of the risks of it. And then Jonathan, maybe to talk a little bit about from a legal side of some things that he might put into an agreement to protect a seller. So Brad first and then Jonathan.
Thanks, Tom. I view an earnout very much as a last resort type of item to raise in a sale process to really only bridge a valuation gap. It's the type of item you want to bring up as late as possible in the process as you can insert, while always, of course, maintaining credibility. I see earnouts as often highly problematic because it can often lead to litigation, and it really is a last sort of hurrah to capture additional value for your client, the seller. The other problem is how, and I know Jonathan will talk to this, but I have found that the higher up in the income statement that you set your earnout hurdles, the better off you are. Because as a seller, you often lose control of how you operate the business, the costs you incur. So to do an earnout over net income versus gross profit can be really very problematic.
Very good
I'm not a
answer,
huge fan of them, Tom.
Yep, and also looking at objective criteria, which I think Phil mentioned. But Jonathan, we might have stolen a lot of it, but you're representing a seller. What are some things you put into the agreement if it's going to be an earnout that kind of protects your client from, like Phil said, that the buyer now controls the financial statements and everything else.
Well, Brad said the single most, the single silver bullet that really goes a long way is if you make it, if the buyer will agree to an earnout based on gross sales, gross revenue, right? That takes all the creativity, absent blatant dishonesty, that takes all the creativity out of the buyer's hands, right? It's not really, I wouldn't say it's market at all. I mean, to do gross revenue earnouts. Brad, have you seen, how often do you see that? I'm curious.
Gross revenue, never. I don't want to say never. I've seldom seen it.
Yeah.
It's people are, the buyer is looking for EBITDA or net income, and the seller is pushing back saying, I want to have more control because I don't know how you're going to be costing things, how you're going to be incurring and recognizing expenses. They can be very problematic.
And to Brad's point, and to answer your question more fully, the earnout should be based on objective, measurable criteria, rather than anything that where subjectivity can factor in. That's sort of the key. You can't have methodology that puts discretion in the buyer's hand. Now, I've done on I don't know if I've ever represented a client where it was done on a gross revenue earnout, but the last acquisition I made on my personal account, we did just that. And
Yep.
and it's painful as the buyer. I mean, you're taking a lot of risk. But if there
Right.
really is a, you want the deal badly enough, and there is just not a coming to, coming together of the minds on what the correct value of the business is, it's a way to do it.
Right.
Um,
One provision too I've seen to protect sellers is that, let's say, you're going to become a division of another company. So unless they keep your company separate, your revenue and everything becomes fictional. So if they do make changes later that basically make it impossible to measure, that the earnout is considered earned.
that's right.
Yeah.
Also, regular, what I think most lawyers would consider, at least most reasonably experienced lawyers would consider as givens. You need covenants to operate in the ordinary course, consistent with past practice, and not to divert business or manipulate costs. The seller needs to have audit and oversight right.
Yes,
Inspect.
that's right. That's another thing. That's right.
Sure.
Right.
Um, the You've got to have a clear dispute resolution process.
I kind of like recommending where if it's possible is instead of is where your seller gets to get an interest in the acquiring firm and treat it pari passu or the same as the other investors. In that way you kind of create an objectivity that you're going to get the same treatment as the others and you're on aligned and stuff. So I find that that's if an earnout starts to be a hairy negotiation, that's a way to go. If possible, sometimes the investments aren't segregated like that.
To just add on, I've had a few situations where people started negotiating the earnouts. And Jonathan, you did a nice job highlighting the complexity. And all of a sudden, the buyer said, listen, for the brain damage and for another $5 million, let's just split the difference.
You're right.
Give you the additional amount now in cash versus, an earnout of, the whole thing. We'll give you a percentage of it today. And often a seller, will be happy to take that discounted amount at close versus a larger amount in the future.
Yes, yes.
Well,
And earnout should go both ways. If they're looking for a price deduction, if you don't hit a certain amount, but you do much better, it should go both ways. I'm going to move to the next question because we've got a lot to cover. So the next question is, do we have tips for running your business while active in the sales process? I'm going to answer it how I would advise a client, and then if anybody sees something different, to add it. But what I advise a client while active is they should focus on running the business as much as possible and let the intermediary, the investment banker, focus on the sales process. And so it's our job to kind of, try to keep distractions to the minimum. So they shouldn't take their eye off the ball. I mean, at the same time, everything is extra critical because you're going to be judged as more than anything on those final months and how things go. So you want to run your business as well as possible. But again, I think their best is to really, they should focus on running their business and let intermediaries. That's a benefit that we provide, is to focus on the sale process. Anybody have something to add on that point, or disagree, or supplement?
Tom, the only thing I'd add is you're exactly right. And for no other reason than if the sale falls through and the owner doesn't run their business the way they've been running it, they're going to diminish the value of the business while they're trying to sell it. So they need to keep moving forward. And I know in some transactions, buyers structure what the seller can do as far as running the business between signing the deal and closing it. But if you don't run it like you've been running it, you run the risk of the deal not closing, and you've taken steps backwards.
And to add to that, Phil, I always say to sellers, you don't want to come to the closing feeling like you have to sell. You always want to have the flexibility that the transaction and the terms are not to your liking, to walk away. And if you've run the business in the ordinary course, you have that flexibility, that autonomy.
Yeah,
A corollary to what you said, Tom, is that there ideally would be a single point of contact, like an internal lead on to interface with the iBank or the lawyers, the other buyers, to insulate as the rest of the, executive team as much as possible from the fatigue of doing the deal.
absolutely. Okay, so we're gonna go to Phil on this, and then Brad can supplement. But what are pro forma adjustments, and when do you see them as most successful in increasing the value of a company?
Well, the pro forma adjustments are the combination of the company from the beginning. And quite frankly, I think it's important for that information to be shared, because if you're in a transaction where somebody's looking for some economies of scale and some cost savings, and a lot of the deals that I do have a built-in 15 to 20% cost savings that's part of the transaction to move forward. And so if you haven't looked at those pro formas across the board on where you're going to get the cost savings, then I think you're leaving value on the table. And that's the biggest area that I see it.
Yep. Anybody have anything else on pro forma adjustments?
I think people often try to adjust for extraordinary events and fluctuations in the market. And I always say to a seller, you always have to maintain credibility. And if you can't articulate the adjustment without laughing, you probably should not be seeking an adjustment and value for that event, whatever that may be. So, and I also would often tell sellers, you want to have material adjustments. You don't want to be adjusting for a bunch of what we call non-material items, because again, you run the risk of losing credibility with your buyer universe.
I agree with you, Brad, wholeheartedly, and also we will even advise if there's like a negative adjustment, that those are also put in there, such as like you've been operating without a CFO for the year, but you really got to replace that position. That can be an adjustment. One thing on adjustments, and this is kind of the state of the art of M&A, is that it used to be kind of fairly informal, and now it's really a battle of the third-party accountants. And so what used to be just buyers, doing their own diligence, then they start using accounting firms, and then there became a whole industry around it, transaction service, providing sell-side due diligence and quality of earnings. And now what is common, and I say almost necessary, is a seller should hire the same type of firms at the very beginning to do a sell-side due diligence, quality of earnings, and formalize the adjustments so they have more credibility. Because one of the important things about also showing them at the beginning is that the buyer is going to do their diligence at the end. And especially the way M&A is played now, it's kind of a lot of people, private equity firms, it's so competitive for deals, will try to tie up at the LOI stage a deal, and then they'll bring in their diligence firms and try to find anything that wasn't disclosed. And even if not really critical to their valuation, they're now going to look to trade down. So to protect yourself, you really want to kind of upfront have a sell side firm hired. Everybody agree on that?
Very much so.
Yeah. Okay.
And Tom, I think it really is. You need to make a thorough review of your balance sheet, because you may have assets. For example, I don't think we're going to have this in a lot of businesses, but they may have an investment portfolio that they have, especially if they're in the lending area, that may be underwater at this point in time. But that's all going to affect the transaction, and you've got to know that on the front end and know where that's going to fall.
Absolutely. Well, here's a topic that I still find tricky and learning and each. So how should a seller handle their key employees? let's say critical employees, and at different stages of the process, it could be different. And, whether it's one thing, whether to let them in, and it's another thing, whether to incentivize them. So I'll leave that. I'll have Jonathan and Phil and Brad, if you have something to add, because this is an issue I think that I'm very interested in the answers.
Well, you threw it out. It's gonna be chaos. You didn't assign it to anyone.
I
I'll talk.
thought that I said Jonathan first.
I didn't want to be presumptuous. So, incentives need to be aligned, right? I guess you're asking more about the timing element of when you communicate.
Well, it's one thing is communication, and another thing is whether you should actually give them kind of incentive for the transaction.
Yeah, I mean, look, there's with a change in ownership, if you've got critical people that need that, if they're not there, the value of the business will be in question. Then it's smart to do something to align incentives. You can offer some sort of a bonus tied to the consummation of the deal, whether it's equity participation or phantom equity. If there, you can enhance an employment agreement with a stay bonus, but certainly an ownership can't be blind to the value of key people.
Yeah. Brad, do you have any thoughts on this topic of informing and whether to give bonus packages?
I think the reason, we all struggle with it is, there is no sort of blanket statement to address this type of issue. It's really got to be case by case. It's one thing if your employees have equity. It's another thing if they don't have equity. It's one thing if a guy is truly critical or gal is critical to the business, So I really have no rule of thumb in terms of incentives and informing employees. I think it's really got to be evaluated on a case by case basis. My basic view, though, is, the fewer people that know, the better. There's no benefit from oversharing until there really is a transaction, and you simply never know if the transaction will ultimately be consummated.
Yeah, I'm not sure I agree with that general view, in the sense that I've found that sometimes sellers are just incredibly paranoid about anybody knowing, and even their most key employees. And I find that we're more successful when they do share it somewhat broader, because I find that people are going to find out, and then they become resentful if they find out through the rumor mill, and it's handled negatively. I find that companies can be overly paranoid, that they kind of restrict even your ability to reach out to the proper buyers. So I kind of go a little bit different, Brad. Over time, I've found I'm much happier when they're shared, and I found there's more benefit generally to having those other managers in on the process, and particularly as buyers come, to have them meet them. As far as incentives, you're right, it's case by case. I have found sometimes actually buyers don't like the employees to be over incentivized, because then they feel that as soon as they become their employees, they don't have as much incentive to work for them. On the other hand, there's a real issue of providing too much leverage to key employees that can actually scuttle a deal at the end. And so these things have to be handled very delicately.
Hey, Tom, I'm going to come down right between y'all. And I'm going to give the best lawyer answer I know. It depends. And really what I say there is I agree with a lot of what both of y'all are saying there. But going back to 2 points, let me make the last one first. I think it's important to make sure whoever has this information early is subject to confidentiality, because again, you want to make sure that all of the announcements and all the communications are timed at the right place. And if you do share information with people early, I've found that it's really important to keep in communication with them. You can't tell them early and then go silent on them, because that's going to cause more concern than not knowing. And so I will say, when you look at key employees, it's really important for buyers and sellers to truly understand who is key, because I have had owners think they are key and felt like they should be compensated more in a transaction, which ultimately can take away from the value being pushed out to shareholders, when in fact, management really wasn't that key. If you really looked at it, the operations people and the sales people were the only reason the business was still there.
This is such an interesting topic, and it just highlights just how thorny it is, and just the fact that we're all kind of saying different things, and it's such an important topic. But it actually is positive for me to just understand that there is no one right answer here, because it's always like it comes up in every deal. Okay, I'm going to shift here to a question that we're going to have Phil start with. How should a business owner realistically plan for the preparation phase before putting their business on the market? And what are key milestones in this timeline? And walk us through the tradition. Well, we'll get to the marketing process, a whole nother thing, but the preparation phase before putting the business on the market. I would say that this is like, kind of, this is after you've hired an advisor and you're about to, you're getting ready to go to market.
Well, the first thing I'd say is you're right. Planning is a key to the success of any of this, whether you're a buyer or a seller, and making sure that everything is in order. It's more than painting the house before you sell it with a business. You need to make sure that your accounting issues are in line, your tax issues are in line, your customer base is committed. But again, when you look at the process, I think what's really important is, even if you're not considering selling your business, my suggestion to any business owner is on a reoccurring basis. It could be annual, it could be every other year, or just periodically assess where you are. Assess where you are as a buyer, assess where you are as a seller, assess where you are in remaining independent, and make sure you have a plan, at least in some form or fashion, that can take you in any one of those directions, where your business is always at the place where it needs to be to maximize the value in the event you sell.
Good answer. Brad, you want to walk us through kind of the traditional marketing process of a company?
Sure. I really break it down into 3 phases. The first phase is really preparing, and you can't spend enough time getting your ducks in the row, in a row. You never want to be surprised as a seller during the process, nor do you ever want the buyer to know more about your business than you do. So the first phase, let's call it 8 to 10 weeks, 10 to 12, you're putting together a teaser, a 1-pager, it's confidential. You're putting together a non-disclosure agreement, a confidentiality agreement, the sales memo. Then you're also, in conjunction with your client, putting together a buyer's list. You then go out to the market and get people to sign the NDA, get people to review the sales memo, and then have them put forth their initial preliminary non-binding indications of interest. That's another 8 to 10 weeks. And the one thing about this process, much like dealing with employees, is there is no hard and fast rules. There is no playbook. And I think if you limit yourself to a playbook, you won't get the result or really be able to subscribe to the priorities and needs of your client. That being said, the first phase is preparation. Second phase is going to market. And then the third phase is limiting the number of buyers the seller is interacting with, having a management presentation so that people can meet one another, and then asking people to refine their bids, put forth a markup of a stock purchase agreement or an asset purchase agreement, negotiate the final docs, and close the transaction, which often that third phase is often the longest phase, excuse me, and can be another 10 to 12 weeks.
That was an outstanding answer. You hit all the boxes. I would say that
Thank you, Tom.
yeah, you're welcome, Pick. It can really vary. Like when we do a distressed transaction and time is of the essence, or there's some other reasons, that first phase can be shortened to about a month. And then you can go another month and then close in, 20 days if you kind of have a, really kind of a deadline. But that last phase also that you talked about takes the longest is the phase where from the seller's point, you're most vulnerable. You're pretty pregnant at that point. You're out in the market, you've expended money, and that's where the leverage shifts to the buyer, and things can happen in the world. So we do everything we can to make that third phase as short as possible, which really, like you talked about, Brad, is really preparing up front, doing the diligence, having a robust data room. Anything that's going to possibly delay you at the end, try to do it up front, such as if you're selling real estate, start that phase one right away. So if there's going to be environmental issues, you can take care of it. If you're going to need difficult releases, disclosure schedules, which can delay the APA, because you're so vulnerable. We try to really have things as tight as possible at the beginning so that we can, hopefully close as quick as possible after the LOI, because that's where you're most vulnerable as a seller and the leverage shifts.
Hey, Tom.
Yeah, Phil.
Go ahead, Phil.
No, Brad, I was going to ask you a question, really, because when we're talking about all of this, I think everybody is wondering, how do I protect myself against competitors? And as you walk through that marketing process, how do you help a seller protect themselves through that process?
It's a great point. I would say there's only a limited number of people that really need to see the most proprietary, sensitive information, whether it's a customer contract, whether it's a purchase order for key materials, whether it's a design that's not patent protected. I would argue that you can give people summary information about that highly confidential information, but there's often only one party that should actually see it. And if I'm a seller, if I'm a buyer in that process, I want to know as well that 15 other guys haven't seen this contract information or this purchase order or whatever the confidential information is. So I think you can give folks summary, non-disclosed information, non-disclosed in terms of who the parties actually are, and just share that very sensitive information at the end.
That's right.
And if I can just add on,
Go ahead,
I think
Phil.
I was trying to get you to mention this too, and I know it's implicit in there, but I tell people all the time, this is stuff we think about, but when we're talking to people that are new to this, they may not. But a non-disclosure and confidentiality agreement is key to that whole marketing process, that they're only reviewing this information for purposes of an acquisition, and they agree not to use it in any other form or fashion.
That's right. Another thing too, on to Brad's point, is that all deals these days have virtual data rooms, which are becoming more and more sophisticated, and you can have different confidentiality levels for different types of people. And so there may be that you don't care the general buyer, sees certain customer names, but you care very much if your number one competitor sees them. So you can kind of have it at a point where there's different levels. And as you get towards the end of the process, you might start to, as we say, go full open kimono.
That's a great point, Tom.
All right, just a little bit more on communication. We really talked a lot about communicating to employees, but Jonathan, communication to customers and other stakeholders like vendors, tell us a little bit guideline on, how to and when to communicate to these other key constituents.
It depends. I mean, as a general rule of thumb, when I advise clients who are selling, notwithstanding the existence of a strong NDA, there are certain disclosures that it's just smarter, like from a practical perspective, to keep close to the vest and not disclose until the very, very end. Um, and key customers are often um, right in that category. The often a buyer will want to talk to customers early on, but unless and until you're really comfortable as seller that the deal is likely to close, you don't want to expose the identity of your customers to a potential buyer. So the timing of communications to customers is, I think it's fair to say, is typically later in the game.
Yeah,
And when the customers are reached out to, if you're dealing with a business that has 10,000 customers, it's different. But if you're dealing with like an 80-20 rule
yeah.
where there's a handful of really key accounts, those require, personal outreach, and real strategy behind the communication.
That's right. I've had situations where we have a severe customer concentration issue. It's not an 80-20, it's 80% is one customer. And we've taken the approach of actually bringing that customer into the sales process to let them know what we're doing and to actually give them, somewhat approval of the buyers. That way, the buyers can know that they're going to have that business, because without it, the business is worth nothing.
That's a great idea. And I've seen as well, I'm sure you guys have as well, situations where you got, 4 or 5 key customers and someone says, I don't want to close unless I've had some interaction. And I always say, not always, but I often will advise a client, you're fine having customer calls, but that has to be done literally 24 hours before close. And there's got to be someone from the company on, and there's got to be some communication with that customer prior to having a call with that potential buyer. And that can only happen with one buyer.
Yeah, great
And
point.
there's a similar conversation to be had about on the vendor side,
Yes.
your suppliers. And it's similar logic. If you're buying widgets and there's 100 awesome suppliers of widgets that are out there, and you happen to be buying from supplier number 72 and 78, but there's 98 other options, that's one thing. But if your suppliers are very bespoke, if it's very difficult to get somebody to replace a supplier should you lose a supplier, you treat them basically the same way as they're crown jewels in terms of information disclosure about them.
I'm going to turn now to something that's Jonathan and Phil, being lawyers, are going to enjoy talking about. It's the legal structure of a sale of a business. And so it's usually in the form of an asset sale or an equity sale. What are the basic differences? And are APAs more common than SPAs or MPAs, and why? Jonathan, we'll start with you, and Phil will dig a little deeper after this.
APAs are more common asset purchase agreements. The reason is buyers tend to prefer that, and buyers are the ones with the bag of money that the seller wants. They have a little bit more control and driving structure. The two basic reasons buyers prefer buying substantially all of the assets of a company as opposed to the equity of the company there's a tax reason and there's a liability control reason. Buyers get a step up basis in the acquired assets, which enables accelerated depreciation and amortization of goodwill and intangibles. From a liability perspective, a buyer can cherry pick, and leaving aside the whole world of distressed businesses, assuming there's plenty of money to go around to pay creditors. Buyers can cherry pick what liabilities they assume and what liabilities they leave behind, and those are kind of the two most basic reasons. Stock purchase agreement, or in the case of an LLC, a membership interest purchase agreement, Those are both buying equity rather than buying particular assets. So by definition, you're not when you're not buying the assets, but you're buying the equity of the company, you're inheriting all of the liability, the liabilities of the company don't change. They are what they are because you're just taking ownership of the company. So there's no cherry picking of assets.
Yeah. Yeah, it's interesting, even though the sales are very similar between an asset purchase and a sale and a stock sale, from a regulation, they're treated entirely differently. A stock sale would be considered a security and has to be governed by the FINRA rules and how you solicit and everything. Whereas the asset purchase agreement is not a security and is not regulated by FINRA. So very different, but very similar results.
Hey, Tom, just two things I'd point out,
Yeah.
and Jonathan did a great job of explaining that, I think, to
Yep.
everybody.
He did.
The the one thing, and I've run across this, somebody buying a business may want to exclude certain lines of business, and excluding assets could be a key. If it's a stock purchase, there is no excluding assets because you're buying the whole thing. But
Right.
in an APA, you could carve out lines of business that maybe the owner wanted to keep that aren't really truly a competing business, and are separate and distinct. And that would be it. And then the other thing would be is that I do think, or at least I have found in my experience, if you're transferring assets with an APA, there may be more expense involved in getting everything transferred over as opposed to an outright stock purchase where everything goes automatically. But again, as Jonathan pointed out, the liabilities associated with buying the stock of a business are such that I think most people avoid that if they can.
Although,
Okay.
if you have if your buyer can get its arms around, it's a question of the ability to do um diligence, complete diligence you have confidence in, and your appetite for risk. I mean, I've done deals where we bought equity, and we, needless to say, we were highly confident about the diligence and we had some appetite for risk. But and we did that because not this it was the seller's preference, but that's not the only reason we did it. And we really wanted the assets. I mean, that's where, notwithstanding the fact I started by saying the buyer has the bag of money, but on the flip side, if the seller has the corpus of assets that the buyer wants, then the seller has leverage. And if you're dealing with, and this is what you were saying, Phil, if you're dealing with a situation where it's the target, the company that's being sold has 2,000 contracts and none of them are freely assignable. In an asset purchase, you're gonna have to go and figure out how to get 2,000 consents to assignment and assumption. That can be a real pain in the ass.
These are
That just
excellent
fulfills
points.
really your point, to do sort of a good housekeeping assessment of your contracts, the transferability of those contracts, understand what your real liabilities are, understand what your tax exposure is. Doing all that ahead of time is just invaluable.
Yeah, and on top of that, Brad, I mean, just making sure that none of those contracts have termination fees. I mean, if you've entered into one and they're not going to agree to an assignment and you cancel it, you may be hit with a large termination fee.
So many good points. The legal structure, why don't we dive deeper actually, Phil, and tell us the major
Tom.
component. Yeah.
But before you take that, I mean, Jonathan, do you want to mention successor liability? Even in an APA transaction, a lot of people don't seem to really follow through and understand that concept.
Sure. So so let's assume it's an asset purchase, and I buy substantially all the assets of Phil's company from from the company, not from Phil, right? I'm buying the assets from the company, technically. The company then will write a big check to Phil, right? And distribute the proceeds of the sale, but my counterparty is the company. But what if the company, and I assume no liabilities. So if I still care that I still have a vested interest to make sure that Phil uses the proceeds before he takes his dividend or distribution, that he sees to it that the creditors of the company are paid. Because if they're not, they may try to come after me. Now, they'll have some trouble coming after me because we just said that I'm allowed to leave liabilities. I'm allowed to only assume the liabilities I want to assume. But there are some legal doctrines that will give creditors of a company, where the company is sold, where the company's assets are sold to me. I bought them. And my APA specifically says I'm not assuming any liabilities. Nonetheless, that's a wall that are supposed to keep out the creditors of the old company from bothering me because I brought those assets into my new company. But there are doors through which creditors can walk based on a couple of legal theories. And the one Phil mentioned is broadly stated, it's the doctrine of successor liability. And it goes by different names in different jurisdictions. What are they? There's alter ego. There's can you remember any of the others?
I really have gotten so used to calling it successor liability or alter ego. I mean, I don't, I'm trying to think of what else it's called. I know what you're saying.
Piercing the veil, but that's a little
Yeah.
bit different. The point is that and there's a couple of different bases for liability. So in the case of a company that was insolvent, if it sells its, and this is designed to, so let's say I'm Phil's brother-in-law or just Phil's friend, and he sells me all of the assets of the company. He causes the company to sell me all of its assets for $1 million, but the fair market value of those assets is actually $10 million. And he just, there was no marketing. He just sold it to me. Um, uh, that's a fraud. That's a fraud on
Fraudulent
credit.
transfer. Yeah. Well, I think I'm going to move it along, but it's obviously a very important thing to consider, and this is why in a transaction you want to make sure you have proper counsel so that you don't step on some of these landmines. Phil, I'm going to go back to you to just let's take a basics. What are some of the major components of the asset purchase agreement and their purpose in the transaction?
Yeah, the first actually would be is what's being bought and what's being sold, the purchase of the assets. The next would be consideration to be paid and how it was going to be paid. There's also representations and warranties of both the buyer and the seller, and those are going to be extensive or limited depending on the transaction and what assets are involved. For a seller, they're going to always be more extensive because you're going to be hitting on a lot of points that the buyer wants to cover. If the buyer is paying cash, the representations and warranties are going to be very limited. Then you move on to covenants, which would be covenants to close, and that would be for both the buyer and the seller. Closing conditions, and that would be basically a bring down of the representations and warranties and the completion of the covenants. You can have indemnification provisions in any APA or merger agreement. Doing that, a lot of people don't stop and think about this, but if you've been providing D&O insurance, you may want to get tail coverage for the insurance of your directors and officers in a transaction if you're selling. Termination of the agreement, or what happens if there's a breach. And the last one I'm going to hit, and it's really interesting to me, I'm finding this at the end of agreements in a lot of instances instead of the beginning of agreements, and that's definitions. And quite frankly, my mind works in the way that I'd rather read the definitions before I start reading the agreement, so I know what I'm looking for in defined terms. But those are a key part of any agreement is defining the terms that are being used throughout the agreement.
Okay, well, I'm gonna go over and Brad, I'll let you take the first crack at it, although lawyers weigh into this heavily, but representations and warranties, what are the most critical ones a seller should be aware of? And what are the potential consequences of breach?
Well, one, I just want to briefly mention, in today's day and age, it's kind of amazing what's happening with rep and warranty insurance. So rep and warranty insurance is, now not just a product for large public deals, but it's being utilized in what we call lower middle market deals where we play. I think the things that you really have to, be confident of is, that the seller owns the equity, the seller is properly formed, that the seller has the legal ability to transfer assets or equity. I mean, there's what they call fundamental reps that Jonathan and Phil can talk about more. And then again, whether or not you have rep and warranty insurance dictates the level and intensity with which you're going to end up negotiating the other reps. If you don't have it, everything's going to be negotiated. If you do have it, you're really going to stick to much more high level type of negotiations.
Yep, good answer. So I'm going to ask from this on the seller's side, Jonathan, and then on the buyer's side, Phil. So Jonathan, what are common representations and warranties that sellers typically make in an APA, and how can they prepare to ensure that they are accurate?
Well, let's see, they would include reps as to ownership of the assets that are being sold, the authority to sell, the condition of the assets, the legality that the company's not doing anything illegal. There's no usually there's a rep, not always, unless a lawyer is committing malpractice. There's a rep that as to there's no, no, that's the way most of the reps are built. The language in the document is, except as disclosed on schedule blank, there is no litigation against the company. And then you need to do your internal due diligence to make sure that if you've got a division somewhere in some other state that there's a lawsuit, that you pick that up and you put it on the schedule. So liens, there's no liens or encumbrances against the assets. Tax filings have all been made. Tax payments have all been made. Those are among the various reps and warranties that sellers typically have to give. And I already said it, I'll say it again. The concept is you got to do, the seller has to do its own internal due diligence, so it knows how to populate those schedules of exceptions,
Yeah.
or else there's going to be a problem later.
Yep. Phil, you want to kind of take from a buyer's to protect themselves from unforeseen liabilities? What are reps and warranties that buyers should insist on?
Well, I think all of those reps and warranties that Jonathan mentioned are the ones that buyers are going to insist on. I mean, material contracts, and I find people don't spend enough time on reps and warranties. They just look at them as standard boilerplate and run through them until they get, like Jonathan said, to the disclosure schedule, and they start thinking about what needs to be on here. And then all of a sudden, it takes an inordinate amount of time to prepare a disclosure schedule that you should have already been ready to prepare as you thought through those transactions. But the accuracy of financial statements, the payment of taxes, compliance with the laws and regulations, litigation is important, that there's no action being taken that that would avoid the transaction. In some instances, I want to know that I'm going to have a certain level of voting for it, and that only a certain number of people will dissent from the transaction, because I want to know if I'm going to get tied up in litigation over the seller's rights or to close the transaction, or if it's going to have any impact on it. So those would be some of the key things that I would look at as a buyer wanting from the seller. As far as what the buyer is going to give in a cash transaction, it's going to be corporate authority, compliance with laws, the fact that I've got the cash to meet the needs in the consideration issue, and that there's no litigation and no action going on that's going to avoid the transaction. I mean, they're really simple if it's a cash purchase from what the buyer is going to be repping and warranting.
Yeah, we talked about at the beginning of the last time about why a person wants an intermediary, and Brad, I think you'll agree with me, but from a investment banker standpoint, when it gets down to the end and you start to negotiate these sellers, reps, and warranties, it becomes a very scary thing for the sellers and for the buyers, because you're talking about all these kind of things that could happen that there's very unlikely, but they're talking about millions of dollars of liability, and nobody wants to be responsible. And it's really kind of like walking your client through a scary forest and holding their hand through it, and making sure that none of these come to breaking points. So that's why, as Brad suggested, rep and warranty insurance has become a big deal, because it kind of takes that risk away and puts it on a third party, because no party likes to put a whole lot of money into escrows and hold it. And so, and also you start to get buyer and seller fatigue going through these issues, because they all feel like they're giving. So you really have to kind of bring the parties together and make sure that they don't torpedo a deal, because, and that's why it's so important to have very good legal representation, such as Phil and John.
And Tom, one other thing I'd add, and would love everybody's insight on this, because in a lot of instances, you're going to have some deferred compensation agreements with management and possibly directors. And that may have been to basically have a succession plan there and keep good employees. So you put that in place, but not understanding the terms of the deferred compensation and what impact a sale is going to have on that could be a real big surprise for somebody. And I know as a buyer, I'm going to want to know if you've got any plans out there from the employee standpoint that are going to be an issue that I have to deal with, like an ESOP that's going to be merged or terminated. I know all of that's beyond the scope of this presentation, but everybody's got to make sure they understand the employee side in any points of compensation, especially deferred compensation.
Yeah. Well, we're getting close to the end. I'm going to have one more question and some closing comments, but MAC clauses, material adverse change. Jonathan, can you talk about how a MAC clause is defined and what it can do to affect the closing of a transaction?
Sure. So basically, material MAE, MAC, MAC, or the C is the change, E is the event, material adverse change, material adverse effect. They're synonyms. And basically, if the company experiences significant negative change, then it gives the buyer the right to walk away pre-closing. They're heavily negotiated. They courts will interpret them, typically will interpret them fairly narrowly. And the they're very much like I said, they're highly negotiated. And they're subject to carve outs. So if a typical MAC might say, if revenue goes down by more than X% or something like that. But there's general economic turndowns and downturns, and industry-wide downturns, acts of God. These kinds of things are usually carve outs, so that if let's say a company's revenue collapsed, but it's because of the next COVID comes along.
Yeah.
If depending on how the negotiated how the MAC clause reads, which is subject to a lot of negotiation, a buyer may not be able to walk away because that might not meet the definition of MAC. So the devil's really very much in the details.
Great. So I'm going to conclude just with this, and I think you guys, it just demonstrates just how the more you know about M&A, the more complex it is. The more, how many times do we talk about it depends? Here's people that have done hundreds of deals and there's still just no one right answer. What I found though over time is that it takes a lot. It takes a lot to close a deal. And if you really don't have two eager buyers and sellers on both sides that want to get to that finish line, the deal is not going to close. You can't force a close. It just, there's a lot, everything will come out. And so M&A is not for the faint of heart. It's not something that you can just put the company and just have somebody come and get a good deal. It takes a lot. And you really got to have people. In the end, you can do all these things and have MAC clauses and limitations and this and that, but you're not going to close that deal unless both sides are committed and want this transaction to get done. So having said that, I want to thank my fellow panelists. What an honor it is. And I learned a lot from this. I want to thank Financial Poise. What a great organization to put these learning out there. And thank you, everybody, and happy deals. Good luck with your years, and thank you for participating. And that's a wrap.
Thank you.
You-
Thank you.